Hey, good morning. I want to welcome all our guests and members. We have 144 registered for the meeting today. I would like to welcome also our new member, Charles Cox, CFP of Canandaigua National Bank and Trust. A note, the regular members are required to attend 2 meetings during the fiscal year from September through June. I want to thank all our sponsors, and in particular, our 2021 Platinum sponsors, Canandaigua National Bank and Trust, Company Wealth Management, ESL Trust Services, LLC, Finger Lakes Financial Services, Inc., Welker, Mose, and DeVelchio, Woods Oviatt Gilman, LLP. 5 platinum sponsorships are sold out for the calendar year 2020, but if your company would like to be a gold or silver sponsor, please contact the Estate Planning Council office or Communications Chair Vicki Klehammer at EFPR Group. As President of the Estate Planning Council, I now call the annual business meeting to order. I want to thank all of the members for showing up and participating during this extraordinary year. Also, thank you to our executive board and officers whose commitment and effectiveness kept the Estate Planning Council relevant and energized. Now, Lynn Carlton, the immediate past president and nominations committee chair, will present the slate.
Good morning, everybody. I'd like to present the first slate of our new executive committee members, the class of 2024. Barbara Clemens, CLU, CHFC, CFP, CASL, and CTFA. Thank you, Barb, you're serving a second term. Jamie Black, CFP, CPA, EA. Diana Donnelly, Esquire. David Germano, CPA, and Ramona Green, CTFA. I'd also like to present our officers for the 2021-22 calendar year. Don Tweetmeyer is our president. Elizabeth Thorley will be the first VP regular programs. Maria Caton will be the second VP of special programs. Mary Zabat is our secretary. Victoria Klehammer is our treasurer. And Lorraine Walsh will be the immediate past president. That is our slate for the 2021 year. If everybody could please, there should be a ballot to vote. If you could vote for the slate for this year, that would be much appreciated. Thank you. Lorraine, you're on mute.
I would like to thank the outgoing executive committee members, Jillian Dart, Alan Pecora, and Kelly Ozak.
It looks like we have a unanimous slate as well as the proxies that came in.
I will officially state that the slate has been approved by the membership. I want to thank Lynn Carlton for her 8 years of service as a member of the Estate Planning Council Executive Board. We have a plaque for you and the other outgoing members, and that will be delivered to you.
Thank you.
You're welcome. And thank you again. Don Twitmeyer, congratulations on being the new Estate Planning Council President. And I thank you for being so supportive in the chair that preceded mine.
Lorraine, thank you very much, and thank you for your year of service here. It's been a very difficult year, and you've been able to get through it all right and get us through it and keep us on the right track as members of the executive committee. I'm looking forward to serving as president this year, and hopefully we're going to start to return to some in-person meetings, or perhaps initially some form of hybrid in-person meetings. I know we've got a nice holiday program lined up for the end of the year. Hopefully it'll be an in-person one if we can. That said, look forward to beginning my term in July and for your continued service there through the end of June. And thanks again, Lorraine. I just have a couple of housekeeping things before we begin with the program. Please note that the speaker evaluation forms will be popping up on your screen when the webinar ends. So please don't leave early, be able to fill those forms out. And that's also some form of proof that the Estate Planning Council has with respect to your attendance at this program. With respect to all my fellow attorneys out there who need CLE credits, keep in mind that you must enter the code numbers on the speaker evaluation form in order to earn the CLE credit. Our speakers will announce those codes during the presentation. Also, the attorneys must turn in the CLE board's revised attorney affirmation form that's available on the Estate Planning Council website, which is epcrochester.org. Now I'd like to turn this back over to Lynn Carlton. Appreciate her efforts, not just on the nominating committee, but for coordinating today's program. And Lynn will now introduce our speakers. Thank you.
Good morning again. I'm really pleased to introduce Rick Marchese. He's a partner at Woods Oviatt Gilman, LLP. He practices in, he concentrates his practice in Medicaid and estate planning, Social Security, Medicare, Medicaid eligibility, planning, and recovery matters. He's also a member of the executive committee of EPC Rochester and is serving today as the attorney of record. He also served for 15 years as the chief counsel to Monroe County's Department of Social Service. Thank you, Rick, for being the attorney today. I'm also really pleased to introduce Dr. Patricia Bamba. She is the vice president and medical director of geriatrics for Excelis Blue Cross Blue Shield, and she serves as the geriatric consultant on projects and programs development affecting seniors. She is nationally recognized palliative care and end-of-life expert who designs and oversees the implementation of community projects. She also chairs the MOLST statewide implementation team and serves as the eMOLST program director and as a member of the Medical Society of the State of New York Ethics Committee. I am really pleased to have these two speakers. I think it will be a wonderful program. Thank you again for your willingness to speak. And I will turn it over to Rick.
Okay, thank you. Let me get this going here. Okay, do you see my slide?
Yes, we see the slides. And Lynn, would you give the first code, please?
Sorry about that. So the first code is 4981. I will repeat that. The first code is 4981. Thank you, Karen.
All right, good morning, everybody. I'm very happy to be here, and I'm so pleased that Dr. Bamba is here. We're very fortunate, actually, to have her. She's so busy. I've heard her speak before. Her presentation is going to be fantastic. And we wanted to focus this morning on it's the title of the program is Changes to Estate Planning as a Result of COVID-19, but we're going to focus not on the financial end this morning, but on the healthcare side. I'm sure all of us have had clients relatives who were severely impacted by the pandemic, which unfortunately is ongoing. It really was, I know, devastating in our practice of elder law at our firm. It's so many clients that I was unable to see, so many families in anguish, people who unfortunately passed away. It was awful. I think all of us have experienced that. And it really brings to light that we can do all the financial and legal planning that we do as practitioners. But in the end, you know, if you don't have your health, obviously it doesn't matter. And what really was the impetus for this program were the inability of loved ones to communicate with patients, with their fathers, mothers, spouses, about what healthcare decisions would be appropriate, particularly at the end of life. And that's what we wanted to talk about today. Dr. Bamba will give the bulk of this presentation. I'm just here as an introduction, really, and to set forth a couple of legal parameters. But her talk will be on the MOLST form, which are the medical orders for life-sustaining treatment. This was really, this question was actually posed to me by a client early in my practice at the firm when we were going over her living will, which was an expression of what she wanted if she was in a dire medical condition. And we were talking about the healthcare proxy, the living will. And, you know, this is the question she posed to me. Why was it so easy for me to come into this world and it's really difficult to leave it? And that question has really stuck with me throughout my career here. You know, it's the MOLST form is designed to ease this question and ease the burden that some families feel about these difficult decisions and medical decisions for loved ones. And you know, from a client's perspective, this is, you know, also been about forms. You know, what forms are appropriate? There's a living will, which is an expression of what one would like if, for example, they were in a coma or in a medical situation in which they had to be supported by artificial nutrition and hydration, what that person would want. There's a healthcare proxy that I'm going to be talking about in a minute. We have a do not resuscitate order. There's an organ donation form, and then there's the MOLST form, which is the focus of our talk this morning. And I've always, again, been struck by the fact that, you know, again, from a client's perspective, you have all these different forms, and how do they work together? How are they distinguished from one another? What is the appropriate form to use? And more importantly, will that form that I fill out be honored by my personal care physician? Will it be honored by the EMTs that come to try to save my life? Will it be honored in a hospital? And will it be honored if I'm in a nursing facility? It's all well and good to fill out a form, but you know, if you're filling out a healthcare proxy, or if a doctor the doctor's order on the MOLST form will be followed, but we want to make sure from a practitioner's point of view that we're serving our client the best way we can by advising them that this is the right form to file, this healthcare proxy, and how it is distinguished from the MOLST form, which are, again, doctor's orders for life-sustaining treatment. So the MOLST form is approved by the New York State Department of Health, and it's implicitly referenced in Article 29 CCC of the New York State Public Health Law. Unlike a healthcare proxy, that's actually under Article 29, it should be Article 29 of the Public Health Law, not Article 28, which can only take, the healthcare proxy only takes effect when a principal who signs the healthcare proxy is unable to make healthcare decisions. And I'll talk about that in a second. So the healthcare proxy, I can sign and designate Don Tweetmeyer to be my agent to make healthcare decisions for me. That designation only takes effect if I am unable to make healthcare decisions for myself. The MOLST, which are the medical orders for life-sustaining treatment, is effective immediately after the doctor and the patient sign the forms. That is the distinction. Again, the healthcare proxy is under New York State law, Article 29, and it carries a few requirements, as it should. The healthcare proxy only may be signed by a competent adult, so the individual has to have competency to indicate that I want my sister or I want my wife to be my healthcare agent. Under the law, every adult shall be presumed competent to sign the form. The healthcare proxy must be witnessed by two people who are not named as agents. There is no notarization requirement on the healthcare proxy, but you must have two disinterested people sign as witnesses on the form. And that basically are the attestation, the signing requirements for the healthcare proxy. Interestingly, another person under the law may sign on behalf of the principal if the principal is competent but unable to sign. What would be a situation like that? A person who has ALS or Lou Gehrig's disease, who unfortunately is unable to move their fingers but is totally competent to make a decision as to who he or she wishes to be their named agent. So again, the agent's ability to act. So if I'm naming Don Tweetmeyer as my agent, his ability to act is triggered upon a determination made in writing by the attending physician that the principal lacks the capacity to make healthcare decisions. This has been a sort of controversy. I know the elder law section of the bar has advocated for a modification of this law, and I have the case that stands for that proposition. Because, you know, an example would be if an EMT is arriving at a house, person has had a heart attack, is maybe unconscious, has been that way for a while. The wife comes out waving a healthcare proxy saying, I am his agent, I am his agent, I want to make decisions for him. Well, there's been no determination yet that the principal, the person who's had the heart attack, lacks capacity to make healthcare decisions. That determination has to be made by a physician. So, you know, that's a situation that, you know, maybe would require an amendment to the healthcare proxy law. And I know the bar has been looking at that, and, you know, as you know, amendments to the law take time, but, you know, that is currently what the law states, that there has to be a determination made in writing that the principal lacks the capacity to make decisions. Another source of confusion, because it's different from the power of attorney law, is that under the law, you can only name one agent to act on your behalf. I can't name Don Tweetmeyer and Lorraine as my agents, one at a time. Notice how that's different from the power of attorney law. The power of attorney law allows you to name multiple agents to act on your behalf. You can have successors named. I can have Don as my first agent and Lorraine as my second agent in case Don is not available to act on my behalf, but it's one agent at a time. Okay. Notarization is not required. Note, most importantly, that the execution of a subsequent healthcare proxy by law revokes all prior proxies. All right, so if you have, and I've had this situation unfortunately twice with warring family members who, brother and sister, who insisted they're in the best position to make a healthcare decision for their father. Brother gets a healthcare proxy signed by the father today. Daughter goes tomorrow, gets her father to sign a healthcare proxy naming her as the agent. That healthcare proxy that the father signs tomorrow, naming his daughter as an agent, by law revokes the one he signed today that named his son as the agent. So, you know, that can lead to, constantly going to the principal to have him or her sign healthcare proxies naming somebody else. Obviously, in a situation like that, that leads to guardianship proceedings in court, and one would wonder about the capacity level of the principal if that individual is constantly signing healthcare proxies. But again, it's important to read the law to understand how revocation is automatic by the execution of a prior healthcare proxy. Well, what has come forth in the pandemic? Okay, notice that healthcare proxies have to be witnessed. And I told you about the fact that it requires 2 witnesses. Governor Cuomo, at the onset of the pandemic, issued an executive order regarding remote witnessing that has remained in effect throughout the pandemic and has really not been modified since it was first issued. This has been really a godsend for attorneys and other individuals who practice in this area. And I'm hoping that remote witnessing actually will be made permanent because I have been unable as an attorney to get into facilities, to get into hospitals during the pandemic. And throughout last year, I was not visiting clients in their homes, and we were not actually having clients come to our firm for a long period of time. Now that's opened. But, how do you witness documents? Well, this executive order provides for remote witnessing. And again, I'm hoping this will be made permanent. What are the requirements? The person requesting that their signature be witnessed, if I don't know that person, if I'm doing a Zoom or a FaceTime, I have a video on the person at their home, that individual, if I don't know them, has to present a valid photo ID, show it to me, and during the video conference. And, so I can see that, Don Tweetmeyer is Don Tweetmeyer. I have his proof. I have his driver's license ID. He shows it to me. The video conference must allow for direct interaction between myself and the witness, and no pre-recorded videos of the person signing. I actually have to see, if I'm witnessing something, I have to see Don sign it. The witnesses must receive a legible copy of the signature pages, which must be maybe transmitted via fax or electronic means. So if Don is signing a healthcare proxy at his home and I'm witnessing it from my office, he's shown me his video ID. I've interacted with him. I've determined that he has capacity, and he has to then sign and send back to me via fax or electronic means, or I've had clients take photographs of their signature and then send it to or text it to me. That works too, on the same date that the pages are signed by that person. And then when that comes back to me, I may sign the transmitted copy of the signature pages and transmit the same back to Don. And then repeat the witnessing of the original signature pages. So Don will have the original. I'll have a self-addressed stamped envelope for him. He puts his healthcare proxy in an envelope, mails it to me, and then I can repeat the witnessing of the signature as of the date he signed it. Okay, so if he signed it 4 days ago, I witnessed it and I complied with all the video notarization requirements, then I'm good to go. I mean, this has been wonderful. I really, really hope it remains because I think clients love it, frankly. It's even if without the pandemic, it would save them a trip to the office. And you're still able, as long as you're able to see a person and assess their capacity and all of these requirements are complied with, I think, you're good to go. So this has been the fundamental, seismic shift in witnessing of documents that has been really wonderful and has allowed for us to witness healthcare proxies and other documents. This, the video notarization, this remote witnessing has been constantly extended. It's currently extended through, May 25th, which is in a week or so, but we always expect it to be reissued, and there's no reason to believe it won't be reissued. There is proposed legislation to make this permanent, and that's working. There are state assembly and state senate bills proposed to make this permanent. We're hoping that'll do that. Okay. And again, I think it'll be wonderful. At this point, I'm going to turn it over to Dr. Bamba, who will give the bulk of our presentation. I'm so happy that she's here. So I'm going to stop my sharing and turn it over.
Thank you so much, Don. I'll be up and started in just a second. So I appreciate your first comment on, in terms of, Rick, excuse me, you've so many healthcare agents. I appreciated your comment in terms of future care planning and so many aspects that this group does in terms of financial planning, legal planning. And today we're going to focus on medical planning and actually having people recognize the normalcy of doing legal and financial planning has been helpful in engaging individuals to do advanced care planning. And so that's something to consider as you're having the conversation. Our objectives today are to really make sure that folks understand the differences between advanced directives and medical orders. Rick set the stage for us. And I want to talk about how to screen clients up for appropriateness and prepare for MOLST discussions. Everyone is not appropriate for MOLST, and I want you to come away understanding who is appropriate for MOLST and also how it's prepared, because it goes to his point, Rick's point, about the confusion about forms. It's not just forms, it's about process. Talk about the authorized providers and how we teach them to complete the MOLST. Make sure that you're aware of some of the changes to public health law that are recent and how that implies to the MOLST process. And then we're going to talk about eMOLST and recognize how valuable it was in the midst of the pandemic that's ongoing. I want to start by defining palliative care, because I find that there's a lot of confusion between palliative care and hospice. And advanced care planning is one of the key pillars of palliative care, along with pain and symptom management, which is an important element of the planning, the care plan that has to be developed after the MOLST is completed, as well as caregiver education and support. Those three key pillars really should start from the time of diagnosis. And palliative care is holistic care with multiple disciplines working together, including attorneys, to be able to make sure that people are provided with the best care. So to me, best care is really good chronic disease management along with these three key elements. And as you move across and you see this hatched line, this is what we call the surprise question. It wouldn't surprise the physician or the NP or the PA that this person might die in the next year. The solid line is, it wouldn't surprise them if they die in the next 6 months. This means they're eligible for hospice. If you just look at the area under the curve, you'll see as you approach that last 6 months of life, and certainly even in the last 2 years of life, you need to focus more on these three key pillars. And that's where MOLST comes into play. Would it surprise you if your client might die in the next year or two? And people don't need to, quote unquote, die on time. I want to illustrate advanced care planning as this rainbow. So when you think of it, advanced care planning is a continuous process. And if you think of it from a population health perspective, everyone 18 and older should have a healthcare proxy. It's the legal document in New York. It needs to include wishes and preferences about artificial hydration and nutrition. It's important to leave that very generic and very global. My agent knows my wishes about artificial hydration and nutrition. because you don't want to tie the hands of the agent, and there's not enough permutations that you can put in that kind of document. And it's not just about death and dying, it's about incapacity, the inability to make decisions, traumatic injuries, sudden illness, sudden inability to make these decisions. And what matters most at 18 is not necessarily what matters at 85 when we're dying. Who we trust to make decisions at 18 isn't necessarily going to be around when we're dying at 85. So this is a continuous process. The healthcare proxy is a legal document. And as you were speaking, Rick, it reminded me of conversations that we heard when I brought together the community-wide initiative back in 2001. And many consumers said, why don't physicians follow living wills? And we'll talk a little bit about that, but that's the essence in terms of why MOLST was created. There is a place for a living will, particularly for that individual who has no one to appoint, not even a close friend, because that it provides clear and convincing evidence of what the person would prefer. But there are really issues with the living will because there's a coexistence of both irreversible illness and reversible illness. And that's one of the examples I will tell you is the person with end-stage dementia who basically at the tail end of their illness will have trouble swallowing. They will aspirate and they'll end up with a fever. And what consumers in our community were telling us is that people would be coming into the hospital. From the physician's perspective, you bring them to the ED, they're there to be treated. They have a fever, they have an elevated white count, they have a pneumonia on their x-ray, they're admitted, they don't get better with IV fluids and antibiotics, they end up in the ICU on a ventilator, which is not what they wanted. And that was one example of many examples why MOLST was created. The important thing is that, and I would really want to comment on the potential amendment to healthcare proxy law. It's an issue and I don't really agree with it because EMS in an emergency cannot be sorting through validity of a healthcare proxy, number one. Number two, EMS cannot take medical orders from a consumer. EMS can only take medical orders from a physician. And they do that today if there is any kind of controversy or a waiving of a healthcare proxy and discrepancy between what's on the MOLST, and they will call medical control. But an amendment that would just allow, would not work to allow an EMS to follow the wishes or whatever is directed from a healthcare agent. Again, I already mentioned why MOLST was created. I wanted to point out, though, that MOLST is not an advanced directive, and that can hang up many attorneys when they go to the DOH website where the regulations include both MOLST. But MOLST is for here and now. It's not for future care like a healthcare proxy. We have a program that was developed in our community with multiple stories, encouraging everyone to choose that trusted person, the healthcare agent, and an alternate. Make sure that they talk about what matters, putting it in writing, and doing the healthcare proxy. So it's not just about doing forms. It's really about communicating. 20 years ago, listening to folks in our community, there were many who were chosen as a healthcare agent that had no clue. And then they were placed in that position where they didn't know what mattered most to the individual. So talking about it is an important part of it. So we've gone from just forms to talking about process. It's a combination of both. You can't just do a discussion without the form, and you shouldn't do a form without a discussion. This program is based on behavioral readiness, learning about directives, identifying why people aren't doing it, motivating, and we have multiple stories that are real stories from people in our community that are in a YouTube channel under Community Conversations on Compassionate Care that people can view and be encouraged to do a healthcare proxy. Then it's doing it right and committing to reviewing and updating it. Knowing that people do it, there's peace of mind. When people don't do it, both the patient and family often suffer. It's important to pick the right person that will be able to step in your shoes and do what matters to you. And it's important to know what matters most. And again, it's for everyone 18 and older. Each one of those clips basically is part of the story and encourages people to do so. So MOLST is a set of medical orders. This bright pink form is the end of a process. It's the end of a communication process. It is not intended to ask the person, if your heart stops, do you want us to start it? If you stop breathing, do you want to be on a ventilator? And I'm going to walk through what that process is, because it's certainly not checkboxes on a form. It's really based on where the person is today. It's choosing the right person based on their health status, prognosis, and goals. I've had, in the last month, interesting before this talk, several elderly patients, or I should say they were members, that contacted me to ask who is the right attorney to help fill out the MOLST. They didn't even understand that this is a form that is a medical order form that needs to be completed by a physician, NP, or PA, and the accountability is there. At the other hand, you can help prepare people for this process of communication. The exception to, and we'll talk about the law in terms of who has authority and accountability, is folks with IDD, because there have been changes to healthcare proxy law, Family Healthcare Decisions Act, but not to the 1750B process. It's important that providers document, and it's the only form that EMS can follow: do not resuscitate, do not intubate, and do not hospitalize, and all healthcare professionals must follow it. It's a common community form, and the point that Rick got to earlier is, what is a form that can be used in all settings? So it really helps with communication within a hospital system as well as across care transitions. Just as a summary in terms of basically looking at the differences, advanced directives are for the future. It's for all adults 18 and older. It's our responsibility as individuals, as patients, to make sure they're accessible. MOLST is a set of medical orders, and until 2018, only physicians had authority and accountability for making end-of-life decisions in collaboration with patients and actually writing these medical orders. It changed, and we'll talk about those changes. And they are ultimately responsible for making sure that these orders are portable. And again, periodic review is required, and only the physician for those with IDD who lack capacity. So this is the flow of normal emergency care. Someone calls, has a sudden chest pain, EMS is called, full treatment is required and provided until the physician understands what's happening, has a conversation with the agent, and if there is no agent, with a surrogate, and there will be a continuation of treatment unless a decision is made to withdraw such treatment. With MOLST, if there's an emergency, EMS is called. EMS assesses in the field. They will go to the refrigerator, look for a copy of the MOLST or the eMOLST printed on pink paper. The patient may not want to go to the hospital. Their palliative care plan needs to be optimized, and if EMS can help optimize it, that's what they will do. But some patients want to go to the hospital. When they go to the hospital, the MOLST form provides information to the physician in terms of what the person wants to receive and avoid now. And that's important because the majority of people who present to the emergency room are so sick, they lack capacity. They'll know, do they want more life-sustaining treatment, or do they want palliation that could not be accomplished in the home setting, or the assisted living, or the nursing home? So there are some screening questions that I teach from a population health perspective that are outlined here to make sure that we know, do people have advanced directives? Do they have a guardianship? Do we have a copy? Is it a people or property or both? And for people with capacity, is there HIPAA release? And for people who are appropriate, do they have a MOLST? And if not, why not? And recognizing it's voluntary, making sure that it's offered to the patient. These are the people who are appropriate for MOLST. Again, I mentioned the surprise question when we spoke earlier about advanced care planning, but it's folks who live in the nursing home. they're receiving custodial care, or they're receiving long-term care services at home or assisted living. People who are in post-acute care pose a different subpopulation today in long-term care, because some are appropriate for MOLST, and increasingly they are, and we can talk about that in the Q&A, but they're not all appropriate, and many will go home and have a life expectancy of many years. People who have one or more advanced chronic illnesses or a primary new diagnosis. You see a client who's been diagnosed with advanced pancreatic cancer that is metastatic, not amenable to treatment. That would be a person that should be offered the MOLST and have a conversation about what they want while they have capacity. And then the last category are people who are bouncing back and forth from the hospital to rehab to home, and they have unplanned admissions. And each time they move back and forth to the hospital, they become increasingly frail. So these are some of the times and the ways that screening be done depending on who is, know who's appropriate, give them questions so that when they go to speak to their physician or nurse practitioner, that they're prepared. This is the protocol. This is the process, and it's only step 7 that the MOLST form is completed. And it's important to understand that you're preparing. Do they have advanced directives? Do they have capacity? And recognizing capacity is task specific. Patient may not have the capacity to complete a MOLST form, but still may have the capacity to choose a healthcare agent. And that's important to preserve the rights and to not require some of what is in Family Healthcare Decisions Act. So that's another piece that we teach. Some patients may not be able to do either, but can relay the need for pain relief because they're in pain. So it's a very nuanced determination. It's not global. And it would be different for someone in terms of financial planning. Someone may be able to balance a checkbook, but they may not be able to manage a stock portfolio. And so walking through this process and making sure people understand each step, how to make these decisions, how to manage conflict, how to have an honest conversation with compassion is part of the process. The other part is really understanding the law. And that is very complicated and far more complicated since Family Healthcare Decisions Act. And there are 5 checklists from the DOH that outline the law, and this needs to be followed with or without the MOLST. There's one for children, and there's the checklist from OPWDD that outlines the Surrogate Court Procedures Act 1750B process. Once MOLST is done, there needs to be a care plan. The patient wants to reside and stay at home and not go back to the hospital. How will their symptoms be managed? Same holds true for assisted living as well as nursing homes. So there are ethical standards that are embedded into both public health law as well as 1750B. The patient's current wishes always take precedence. You know, when we look at substituted judgments, we need to recognize that we're not translating an advanced directive, but we're using it as a guide. And it's only done when the patient, as Rick said, is incapable of making those decisions. Best interest means if I don't know the wishes, I don't know what matters most, I can't make those decisions. I will make it based on what is in the best interest of the person. And legal requirements vary depending on who makes the decision, where it's made. And again, in going back to that, that's an important part of that first step, that providers understand the law and ethics that are embedded in the law and how to make these decisions. Clearly, if I have capacity, I make all of my own decisions. If I lack capacity as determined by my physician, NP or PA, with a concurrent determination, then healthcare proxy law goes into kick. It's important, and I teach this to the providers all the time. This is not a healthcare agent-centric decision. Same holds true for Family Healthcare Decisions Act. The law requires that decisions be made in accordance to the patient wishes or best interest. An 85-year-old woman, when I first started practice many years ago, said, "Everyone gets one chance to live. Everyone gets one chance to die. You need to listen to what I want, and you need to be able to help me along the way." It's important then to recognize that as we move into Family Healthcare Decisions Act, that these are for people who don't have a healthcare proxy, or the decision maker is that surrogate list in the law. It also includes hospice in terms of the definition of hospital or nursing home. So this checklist 3 applies in that setting. And the important piece about Family Healthcare Decisions Act to recognize is that when it went into effect, as Rick said, Article 2977 was repealed, and there was a new public health law, 29 CCC, that governed non-hospital DNR orders. The Family Healthcare Decisions Act is Article 29 CCs, and the MOLST is the only alternate form approved by the Commissioner of Health under 29 CCC, as per successful legislative community pilot that occurred in both Monroe and Onondaga counties from 2005 to 2008. Unfortunately, when we put in the legislation in 2005, that got passed in 3 weeks at a time when the budget didn't get passed, because people felt so strongly that MOLST was important that we didn't put the term in, because we weren't sure that MOLST would be the retained term, and we knew it would be hard to change it if it was embedded in public health law. We can talk in the Q&A about what we're trying to accomplish in terms of embedding that term so that it can be found in the midst of legal search, because oftentimes people will not see the language, the alternate form approved by the Commissioner of Health, which is the late Commissioner Daines, and they'll say MOLST is not in public health law. Here is the surrogate list, and it's important that people understand that, and it's clearly defined in the law. I put here the dates in terms of when NPs and PAs became the authoritative providers to be able to do this. The other piece that's important to recognize, when Family Healthcare Decisions Act came into play, that clinical standards changed. When I was in practice and prior to Family Healthcare Decisions Act, there was something called there was a therapeutic exception that a physician could put in an order for DNR if they thought that the patient could not tolerate a conversation. That no longer exists. The other piece is that there were 4 clinical standards in the DNR law, and medical futility was eliminated in Family Healthcare Decisions Act. It's no longer a clinical standard. There is a legislation that's been recommended to replace that. I'm not sure if that's going to happen anytime soon. It's been in play for many years. The other piece is understanding the clinical standards, and they're either extraordinary burden and death in less than 6 months or permanently unconscious, or irreversible, incurable clinical condition and extraordinary burdensome suffering. And so helping our providers to understand that, helping the clients understand if that's really what happens if they don't have a healthcare proxy. It's another reason for people that are very sick, even when they are ready for MOLST and they don't have a healthcare proxy, to make sure that that's done. There are also special requirements that vary from the hospital to the nursing home, and ethics review committees are required. In the hospital, there's only one time, and that's when the attending objects to a decision to withhold or withdraw artificial hydration and nutrition. In the nursing homes, it's anything other than the DNR order. These are the dates, and you have these in terms of the decisions, in terms of when the law, Family Healthcare Decisions Act and Healthcare Proxy Law, were amended to allow NPs to not only sign a MOLST, but to also have accountability for that process to make sure it's done correctly. Similarly for PA, everything got done in one fell swoop as of last June 17th, 2020. Checklist 4 is part of Family Healthcare Decisions Act when there's no one, not even a close friend identified. And in 2015, Family Healthcare Decisions Act was amended importantly because the standard when it was passed in 2010 was quote unquote imminently dying. It was not defined in the law, and it was very difficult to help providers across the state because it was being defined depending on where the patient was residing. It was being defined variably. And it was very important for this to change because it's not as clear, it's not as swift to get guardianship through for some, particularly for this population, frankly. Guardianships take a long time, and that's really been a concern. And so the important piece that got changed in the law is when a person who has no one and is hospice eligible, they can be enrolled in hospice and have a plan of care that includes life-sustaining treatment, that includes MOLST, and the requirements under Family Healthcare Decisions Act align with Checklist 3. And this is an important change. And it's also a reason that I teach providers how important MOLST needs to be reviewed and updated. It needs to be reviewed and updated regularly because it's medical orders. Checklist 5 is important because it's for children. And prior to 2010, there was no law governing anything but DNR. And it provides for when there are, parents who are divorced, when there are guardians, et cetera. And so it's beyond the scope to get into details of that today. And actually, I skipped this important one, which is Checklist 5. Checklist 5 is basically people who are in the community, because Family Healthcare Decisions Act really is looking at hospital, nursing home, includes hospice. So what do you do in terms of life-sustaining treatment for people who lack capacity, they don't have a healthcare proxy, and MOLST is being done in the community? Community would be including places like assisted living that have a dementia unit or a person that's at home. And so this is really the law, and it's outlined for you so that you understand how MOLST is encompassed in Family Healthcare Decisions Act. It's been approved for use in hospitals and nursing homes as far back as 2005. The health department supported this legislative pilot and helped to revise and bring out the 2005 MOLST form when it approved it. That pilot that was in these two counties not only looked at data for EMS, but hospitals and nursing homes. And we were able to show that EMS could read and follow both DNR and DNI on this alternate form, i.e. the MOLST. So a non-hospital DNR form, the old white form, you can't add DNI on and expect EMS to follow it because it's not compliant. This is the only form, and EMS is trained on it. It was signed into law by Governor Patterson, July 7, 2008. And as I said earlier, as part of Family Healthcare Decisions Act, there was a new Article 29 CCC that governed non-hospital DNR orders. Because of this pilot, surrogates under Family Healthcare Decisions Act have the authority to make both DNR and DNI decisions in the community. And then clear and convincing evidence, as recognized by case law, can then provide for the other decision-making. And that includes a living will as well as repeated oral expression. Honestly, this is how we were using MOLST across the board in all settings when people didn't have a healthcare agent, and why we developed the second program to encourage conversations and getting everyone to do a healthcare proxy, because you don't know if or when or how you might be in this position. Notifications are required, certainly with the adult population. And as I said earlier, for children, there's a whole checklist that outlines the requirements. For surrogate court 1750B, there is a checklist. It has to be completed. It needs to be accompanied with the MOLST form for the MOLST form to be honored. This is the identification of the surrogate list. There are 6 steps and a very complex process, requirements in terms of who can provide capacity determination as outlined in 1750B, as well as medical necessity, notifications, depending on whether people are in a facility or receiving services at home. And all of this needs to be done in this process with no objection before step 6 that the physician then signs, as well as then can sign the MOLST form. And so there are 3 different pathways, so to speak, just in summary, for those with IDD. A person who has capacity can make their own decisions. A person who has a healthcare agent can make their own decisions. A person who lacks capacity needs to follow 1750B and these clinical standards that are outlined on this slide. And it's important, I always teach the providers to make sure that the documentation is complete. And so if you're caring for any clients or family members or guardians, and they're frustrated with this process, oftentimes it's because there's insufficient documentation. And increasingly, I've seen clear changes as over the last 15 years since 1750B has come into play, as well as particularly in the last 10 years, once MOLST, the new MOLST form in the DOH MOLST form in 2010 was also really fully embraced by OPWDD. So what do I mean by shared decision making? It means how do we make decisions, not just in the old way, in the old school, when I was in first learning medicine, which was paternalism. Basically, doctors made decisions, patients trusted them. Moving over to autonomy, expecting people to make decisions, which is clearly not possible in this very complex world, to really working together to help to make decisions, as well as it being okay for the physician to say, this is complicated, I'm not making the decision, this is what I would advise. And the questions are, will treatment make a difference? What are the benefits and burdens? How will it help? How will it hurt? Is there hope of recovery? Is there hope of getting better? And the important part to emphasize is what's life going to be like afterwards? And then it goes to the important question is, what does the person value? What matters most to them? What are the goals for their care? Because, and I'll give you an example. If my physician said that this treatment, the best I could hope for would be to reside in a nursing home and be on a ventilator with a peg tube and never to recognize my grandkids, versus I'll be out there being the best Babshi I can. And if what matters most to me is being the best Babshi I can, which is Polish for grandmother, I'm going to make different decisions based on the outcome or the expected outcome of what life will be like afterwards. In terms of resuscitation, it's just important that people define what it is. A heart stops, you stop breathing, you're dead. It's an attempt. Is there a desire to have an attempt to restore cardiac rhythm and resuscitation, or do you want to allow a natural death? And that's on the MOLST form. It's language that really reflects what many people tell us. I just want to die naturally. I just want to die peacefully in my sleep. Importantly, for people who are appropriate for MOLST, it is not a procedure that necessarily works. And if it does work, people will be transported to the hospital, intubated, and they will be in the ICU. And for some subpopulation, the frailest in nursing homes, if they recover from CPR, they are not going to survive. Those are the facts, and it has to be conveyed gently. It also doesn't mean the same as do not intubate, which is really when people still are breathing, they're having trouble breathing, they're not dead. And it certainly doesn't mean do not treat. And that's a confusion that oftentimes people think that if I choose in order to not be resuscitated, and I know it won't work, that I won't get other good treatment. And the important piece of MOLST is to outline what it is that you want still, what is it that you don't want based on your goals. It's important, and I share this, it's very person-centered. You have to understand the person, you have to understand the mortality rates, you need to take all that information and understand what their expectation is. And if someone has both chronic lung disease as well as kidneys failing and has cardiac symptoms, you can't just use one of these tools that looks at only one, what I call organ system. You can't listen to one organologist saying that you're going to survive without really looking at all of the whole body holistically. It's also important that people understand trial periods, and a trial period is really to see if this treatment may be beneficial based on goals. And I should mention that in terms of trials, there's no medical, ethical, or legal distinction between withholding or withdrawing life-sustaining treatment, because if there were, people would not choose a trial because they'd be afraid that they couldn't get off. We also have guidelines for feeding tubes, and if you're looking to help guide your clients, we have developed these back as far back as 2004. They are updated biannually. They were last updated last January, and they're both on our website, MOLST.org, as well as on the Monroe County Medical Society's Community Guidelines website. This is just one of many tools in the toolkit that help providers to understand the evidence base currently, as of now, based on different disease categories. And then finally, hospitalization and transfer preferences and the importance of that palliative care plan. The resuscitation, respiratory support, and hospitalization are those emergency orders that we saw during COVID. Another piece I wanted to make sure that we went over is what a healthcare agent and surrogate can and cannot do. And this is from Jonathan Carmel from a briefing he did with Family Healthcare Decisions Act, emphasizing in the law that there's no surrogate decision-making when the patient's already made a decision. This is what is on the MOLST form. They have made a decision with capacity. It's clear and convincing evidence of their desire to withhold certain life-sustaining treatment. Again, in terms of the law, it's important, as I said earlier, to know it's based on the patient's known wishes or best interests, not the healthcare agent or surrogates. What can and they cannot do? What they cannot do is they cannot undo decisions that the patient made. So flagging that healthcare proxy in the field when there is a MOLST form properly completed that says, I don't want to be resuscitated, I don't want to be intubated, healthcare agents do not have the right to undo that. And EMS doesn't have the ability to sort those things out. Same holds true in a hospital setting. You cannot undo those decisions that were made to withhold treatments. What you can do is make decisions about further treatments that were full treatment. Or if a person said, my goal is to see my grandson have his bar mitzvah, and I want to be able to have all treatments, and clearly wanted the MOLST to reflect that, and then has a catastrophic stroke that he's not going to recover from, the healthcare agent or surrogate can then change the MOLST. I'm going to go through, and then we're going to open up for questions, talking a bit about eMOLST because it's best practice. What is eMOLST? It's a secure website. It is a registry of the MOLST forms in an eMOLST. It's a statewide registry. It's person-centered. It's integrated with EMRs. It's not required. It takes that whole process of the 8-step protocol, those 7 checklists, and it walks through a standardized process online so that the provider can focus on the conversation and clearly make sure they're following the law and the ethics. And if they're not, then the system doesn't allow them to do what you can't do. It does not allow you to put it in a CPR, do not intubate order. I want to have CPR, but I never want to be intubated. That's a medical error. It doesn't allow for that. And in that way, it improves quality and patient safety, and it provides access within the hospital setting and across care transitions. It's the Bible. It retains all of that information. And as per the directions from DOH, when an old form is voided and a new form is completed, there's a void that's watermarked across. So there's only one form that can be retrieved, and that's the current medical orders, as well as a copy of the discussion. These are stats from last year, and you can see the impact of COVID in terms of the increase of providers that are users, as well as live patients in the system. And you can see the average age being 82 because it's all comers. And you can see it's not 100%, I don't want this. It's really about patient preferences and in terms of what people wanted. The only data I have about MOLST is in the eMOLST system. I don't know necessarily what happens in the paper world during COVID, but I can tell you that 20% of the medical orders were reviewed and renewed with changes particularly related to resuscitation, respiratory support, and hospitalization, that there were parts of the state where eMOLST was used for many years where patients were calling in to change their medical orders. People came in from multiple states in New York City where it's being used and were able to follow all of the public health law by using eMOLST, and found it was such a help to be able to do this that they've taken it back to their own states to use. So it can be integrated with an EMR. It's integrated with RIOs. It can be linked, but it can be a simple icon on a desktop. There are different pathways for integration that are outlined here. It's been referenced in ONC's report in 2019, and it was just like the healthcare proxy. And I agree with Rick. I hope that the legislation goes through to continue to have the virtual witnessing for healthcare proxies. Similarly, it was this new world and the shift to telemedicine that really escalated the use of eMOLST. It can be used for all patients. As I said, it integrates all of the process we talked about. It's immediately part of the registry, but if it's not completed and patients they're not ready yet, all of the discussions are still documented in the registry and can be retrieved. It has PDF functionality so that it can be printed on pink paper and a copy can be given to the patient if they're going home. It can also be transported across care transition, so EMS has access to it, and it makes sure that all of the documentation is done seamlessly. I'm going to end with a case and talk about the value of eMOLST through the vision of an 80-year-old woman who I had the privilege of meeting up in the North Country in a critical access hospital when her husband, who was 82, was being discharged. He had chronic lung disease. His heart was failing. His kidneys were failing. He had had a part of his lung out for lung cancer, and he came in not being able to breathe. The doc in the ED did all of the appropriate treatment, was about to intubate him and transport him down to Upstate Medical University. But because he was trained and had access in eMOLST and had come to training, he went to a simple icon on the desktop in the ED and saw that the doc in the community had done eMOLST in the system. And unfortunately, the form was left on the refrigerator, but the patient had said he didn't want to be resuscitated, he didn't want to be intubated. And he was continued with conservative treatment, survived that hospitalization, was being discharged, went home, and died peacefully at home 2 months later. That's the value of the eMOLST system from both the patient's perspective as well as the provider's perspective. So just in summary, advanced care planning is a continuous communication process. There are differences between standard medical care, advanced directives, and MOLST. MOLST is not an advanced directive, rather it's a set of medical orders. It's completed after a process. It should be reviewed and renewed at least every 90 days when there's a change in health status or prognosis, when people move across care transitions, and when the patient changes their mind. eMOLST is best practice, provides that coordinated care, and ensures access across care transitions. There's a host of resources. I would just call your attention to compassionandsupport.org, which has been around since the community initiative I led in from 2001 to 2003. This was started as a community initiative by one of the consumers, and it's been updated in 2007 with a grant, and then redesigned in 2018 to have 2 population health sister websites, one for the general population, one on MOLST, and they're all integrated. There's a host of communication skills and active links that you can take a look at. Thank you very much for your attention, and I will stop sharing and entertain any questions.
Thank you, Dr. Bamba. That was a wonderful, wonderful presentation. I am going to give the second code before I read the questions to you. The second code is 5563. Again, 5563. I do have a couple of questions in the chat, and I will give those to either Rick or Dr. Bamba. If there is a disagreement between what the doctor is recommending and what a healthcare proxy agent is directing, what happens?
Well, first and foremost, nothing happens. The patient will continue full treatment until that conflict has been resolved. And so part of teaching the MOLST process is really teaching conflict resolution and understanding where that conflict is coming from.
I think people also misunderstand, Doctor, the healthcare proxy. If I'm designating Lynn as my agent and I have a living will that expresses that I do not want artificial nutrition or hydration, that's an expression of what I want. She doesn't necessarily have to follow that because I'm designating her as my agent. I've entrusted her to do that. And I would hope if I filled out a MOLST form, that the MOLST form would be, I mean, with the doctor or with the NP, that would be honored because I was executing that at a time I had capacity, right?
And I think that I was looking at it from the lens of MOLST,
right,
as opposed to the healthcare proxy alone before making MOLST decisions. And so in terms of the healthcare agent stands in the shoes of the principal or the patient and has the authority to make those decisions. But I try to express that this has to be a shared decision-making process. And I know that personally, I've been involved with a case where a healthcare agent had been abused, still was the authority and wanted to continue treatment, lighten someone on sedation while he was in the ICU with tears and really wanted to stop the treatment. The healthcare agent, once I understood that, was able to understand more what was causing what was inappropriate treatment. And so you always have to get to the source. And so if it's not the right medical treatment, it's not just like the healthcare agent can do and read and interpret a living will, because living wills are created oftentimes 20 years before, and they don't reflect necessarily what people want. And I would just say one thing, it's important to recognize you can't even assume to have all the permutations put into a healthcare proxy or a living will. You just can't predict because none of us have a crystal ball to know what's going to happen in the future. So that's where I was coming with conflict. If there's conflict against good medical treatment and a healthcare agent wanting this kind of treatment, it's not really the living will that's guiding it. It really is understanding why is it that a healthcare agent is wanting treatment that is not in the best interest of the person.
The second question is, could you please clarify how our clients get the MOLST process started? Will the provider initiate the process if appropriate, or should the patient ask for it?
I think it's both. And I think it really is, there's a continuous influx of new providers. How many actually know what MOLST is? If they've just come to our state and have, you know, not been familiar with the MOLST, I encourage patients, if they think they are appropriate, to make an appointment. I get called all the time, or I get emails, you know, from individuals ask that question all the time. And I say, let's have a conversation. It's not an email conversation. And I basically try to assert myself whether they're appropriate. And if they are appropriate, encourage them to call for an appointment, but also call for the right appointment so that it's not mixed in the middle of the day or squeezed in, and that it's a time where their healthcare agent will come with them so that they can hear the conversation, because that's conflict prevention. That's going to prevent that healthcare agent waiving that healthcare proxy saying, I want to change the MOLST, because they were part of that discussion.
And this is a great follow-up. Why is it that so few doctors seem to be familiar with the MOLST? I find myself, and this coming from attorney, I find myself recommending that clients discuss MOLST with their doctor, and doctors are often unfamiliar with it.
I have spent the last 2 decades educating, and I can't give you an answer except that professional training and education is an ongoing process. And so we have done conferences, we've done webinars. We currently do eMOLST, which is based on Project Echo out of New Mexico, and it's online training and it's case-based. It's wonderful training. And so it's something I didn't put in the slides, but you could recommend to your physician clients. To be honest, you all have physician clients, I suspect. So you can tell them on the bandwagon, help me out, because there will always be new physicians that need to be trained. And right now, I would just give you a backdrop in terms of the MOLST team. We have multiple committees that have formed. One is on education and training, trying to address not only this question about sustainable education, getting all physicians, but now all nurse practitioners, all physician assistants. And we're creating the models aside from eMOLST to try to make sure that that's done. I've tried to integrate that into the curriculum of every medical school unsuccessfully, as well as every residency and training and fellowship program. So your help is required, and I'd be grateful for it.
Is there any other questions? I don't see any other in the chat. Having said that, I'd love to turn the program back over to Lorraine and Don so that we can end today's session. Thank you again, Dr. Bamba and Rick. I really appreciate it. It was a great discussion and certainly very helpful to us today.
Well, as my last official duty, I want to thank Mr. Marchese and Dr. Bamba for a very informative and important program this morning. And as a token of our appreciation, you'll be sent a gift card in the mail. I want to remind all our members that the next meeting is September 9th, which will be a Zoom webinar and will be topic changes to estate planning part 2 as a result of COVID. And our speaker is John Owens, and he is a CFP with Brooklyn FI, and that's the name of the company. Thank you again, and have a safe and enjoyable summer.